Have you ever wondered what happens when you've lost your case at every single level and there's only one door left to knock on? Well, that door leads to the Supreme Court, and the key is a very specific, and let me tell you, a very demanding legal tool called Rule 45. Today, we're going to demystify that final appeal. So picture this. You fought a long, hard battle in the trial courts, you went to the Court of Appeals, and you lost. You're facing a final defeat. What's next? What's that last-ditch, high-stakes move you can possibly make? That's exactly what we're breaking down today, the petition for review on certiorari under Rule 45. So here's our game plan. We'll start with what makes this final appeal so unique. Then we'll talk about beating the clock on some really tough deadlines. After that, we'll get into the secrets of crafting a perfect petition. Then we'll look at the gatekeeper's verdict, and finally, how you might just earn that golden ticket, a full review by the Supreme Court.
All right, first up, the final appeal. What exactly is this last stand? And more importantly, what makes it so different from every other legal move you've made up to this point? Okay, let's get the single biggest point of confusion out of the way right now. A Rule 45 petition is a true appeal. You're arguing that the lower court made an error of law. This is totally different from a Rule 65 petition, which is an original action where you claim a judge acted with grave abuse of discretion. See the difference? In Rule 45, you sue the winning party. In Rule 65, you're actually suing the judge. They are not, and I repeat, not interchangeable. So, the most important thing to grasp is that Rule 45 is only for questions of law. What does that actually mean? It means the debate over the facts is over. It's done. You don't get to re-examine evidence. You're only allowed to argue about how the law was interpreted or applied to the facts we already have. You know, a question of fact is, did Pedro stab Juan? But a question of law is, okay, given the facts of the stabbing, does it legally qualify as treachery? Big difference. And that brings us to the golden rule of this entire process. If you take away just one thing from this section, make it this mantra: law only, no facts. The Supreme Court is not a trial court. It's not going to sift through evidence again. Your entire case, your whole argument has to hang on a pure question of law.
Okay, so you're confident your case is all about a pure question of law. Great. But now comes the race against time. Let's move on to our next section, beating the clock. And trust me, these deadlines are absolutely rigid. This part is totally non-negotiable. You have exactly 15 days from the moment you receive the denial of your motion for reconsideration to file your petition. So if you get that bad news on March 1st, your deadline is March 16th. But, and this is super important, you can file for one 30-day extension. If the court grants it, that would push your final deadline to April 15th. But getting that extension isn't a given. You have to follow these 3 steps perfectly. First, you have to file the motion for extension before that initial 15-day clock runs out. Second, and this is a classic mistake, you have to pay the full docket fees right then and there when you ask for more time, not later when you file the actual petition. And third, you need to give the court a good reason why you need the extra time.
So, what's the big takeaway here? Just burn this simple formula into your brain. 15 plus 30. You get 15 days with one possible 30-day extension. That is all you get. Period.
All right, you've mastered the timeline. Now for the main event, actually writing the thing. This is where cases are won and lost on pure technical perfection. Welcome to Petition Perfect.
Before you even type a single word of your brilliant legal argument, you need to get this procedure down cold. And the absolute first rule is this: pay and serve first. That means you have to pay all the required fees and serve copies of the petition on the other party and the lower court before you officially file with the Supreme Court. It's a jurisdictional requirement. If you forget this, your petition is, I'm sorry to say, dead on arrival.
Now, for a number that trips up so many people, 18. You have to file 18 copies of your petition. You might be thinking, why so many? Well, the logic is pretty simple. There are 15 justices on the Supreme Court, and each one needs their own copy to review. The last 3 are for the court's official records. It seems like a tiny detail, but getting it wrong can get your case thrown out before it's even read. To help you avoid those fatal technical mistakes, here's your essential checklist. Just remember DNSCC. You need the material dates to prove you filed on time, the names of the private parties only, a crystal clear statement of your legal arguments, certified true copies of the decision you're appealing,
And finally, the sworn certification against form shopping. Miss any one of these, and you are in serious trouble. So you've filed your perfect petition. It's a work of art. Now it's in the hands of the gatekeepers. What happens next? The court's going to issue its verdict, and it's so important to understand the two main ways you can lose. Look, it's so important to understand the two ways your petition can be rejected. It can be dismissed or it can be denied. They are not the same thing. A dismissal is about technical problems. You failed on form. Maybe you forgot to pay the fees or attach that certified true copy. A denial, on the other hand, is about the merits of your case. It means the court read your argument and, nope, they found it had no substance. They're telling you your legal reasoning just isn't strong enough. So the mantra here is really simple but powerful. Dismissed for form, denied for substance. One means you messed up the paperwork, the other means you messed up the argument. Both are the end of the road, but it's really important to know why you lost. But hey, let's say you survive that first cut. You've nailed the form and your argument seems solid. How do you actually get the court to take your case seriously? This brings us to our final and maybe most important section, the golden ticket. Let's just start with the rule itself, because it's pretty humbling. It says, a review is not a matter of right, but of sound judicial discretion. Let that sink in. What it means is that you have no inherent right to be heard by the Supreme Court. You have to earn their attention. You have to convince them your case is special, that it's important enough for them to spend their incredibly limited time on it. So what does special and important actually mean? Well, it usually boils down to two things. First, novelty. Your case brings up a brand new legal question that the Supreme Court has never, ever ruled on before. Think about cases involving new technology like AI or cryptocurrency. Second is departure. This is when the lower court has just gone completely off the rails, basically ignoring established legal rules and precedents in a pretty shocking way. And if you can convince the court of either of those things, novelty or departure, you might just get that golden ticket. The magic words you're looking for are that your petition is given due course. That's the phrase every petitioner dreams of hearing. It means the gatekeepers have let you in. The court has decided your case is worth their time and will be fully reviewed, studied, and decided with a full written decision. So at the end of the day, after all the deadlines, all the fees, all the formatting, it all comes down to this one single question. It's the filter that the Supreme Court uses for every Rule 45 petition. Is your legal question novel enough? Is your case important enough to command the attention of the nation's highest court? That right there is the strategic heart of Rule 45.